Marriage is often portrayed as happily ever after, but the reality is that not all marriages last. Welcome to the very first episode of Family Law Diaries, brought to you by LiveLaw. I'm Shambhavi, and in this series, we'll break down various aspects of family law, issues that affect everyone but are often misunderstood. Whether you're in the legal field or simply curious, we'll make complex legal topics easy to understand. Today's topic is something that many people talk about but few fully understand: divorce and separation. Let's uncover the myths and discover the realities. India is a diverse country, and so are its laws regarding divorce. Hindu, Muslim, Christian and Parsi communities have different legal frameworks. Hindu, Sikh, Jain or Buddhist is codified and governed under the Hindu Marriage Act 1955. For Muslims, the Muslim Personal Law, Shariat Application Act 1937, as well as Muslim Dissolution of Marriage Act 1939 governs divorce. For the Christians, the marriage and divorce are governed under the Indian Christian Marriage Act 1872 and the Divorce Act 1869 respectively. Apart from personal laws, the Special Marriage Act 1954, which is a secular law and allows parties of different religion and caste to be married, governs these matters in relation to those parties. In India, under the Hindu Marriage Act 1955, couples can file for divorce on various grounds such as cruelty, adultery, desertion or mutual consent. However, it's a time-consuming process with mandatory waiting period of 6 months under mutual consent divorce. The court ensures that every avenue of reconciliation is explored. Now, before going ahead, let's quickly cover what are the valid grounds for divorce in India: adultery, cruelty, desertion, conversion, mental illness, leprosy, venereal disease, renunciation, and presumption of death. Under Section 13 of the Hindu Marriage Act, cruelty, both physical and mental, is one of the most common grounds, but is also one of the most controversial. So in cases like Naveen Kohli versus Neelu Kohli, the Supreme Court highlighted mental cruelty as a valid reason for divorce. Section 498A of the Indian Penal Code addresses cruelty to wives, but it has often been accused of being misused. While the law has enacted to protect women from dowry harassment, it's important to balance protection and preventing misuse. Courts have been mindful of this in cases like Rajesh Sharma versus State of Uttar Pradesh, where guidelines were laid down to prevent the misuse of Section 498A. But before moving forward, let me quickly tell you a little about this case. It's very interesting. Rajesh Sharma and Sneha Sharma married in 2012. After Sneha's pregnancy was terminated, Rajesh and his family allegedly abused her for dowry. Sneha filed complaints under Sections 498A and 323 of the IPC. The Sessions Court convicted Rajesh, but when Sneha summoned more of Rajesh's family members, the case became contentious, leading to an appeal in the High Court and later the Supreme Court. So the key issues in the case was whether all family members of the accused should be automatically implicated under 498A. The Supreme Court issued guidelines to prevent the misuse of Section 498A, including the formation of a family welfare committee to review cases before any arrest. So, divorce and separation are often shrouded in myths. People think that divorce is easy, fast, or that the spouse who cheats automatically loses everything. But the truth is much more nuanced, and legally things can get complicated. Let's begin by breaking down some of the most common myths and contrasting them with legal realities. Myth number 1. Divorce and separation are the same thing. One common misconception is that separation and divorce are the same thing. But legally speaking, they're very different. Divorce is a legal dissolution of marriage. Once a divorce is finalized, the marriage no longer exists in the eyes of the law. In separation, couples may choose to live separately without legally ending the marriage. In India, we have the concept of judicial separation under Section 10 of the Hindu Marriage Act 1955. This is a middle ground where spouses live apart, but the marriage still exists. So in judicial separation, the couple remains married but is not obliged to live together. This is often used by couples who are not ready for a full divorce but need some time apart. Myth number 2. The cheating spouse always loses everything. Many people believe that if one spouse cheats, the other automatically wins the divorce, taking the house, the children, and all the money. While infidelity is a factor in divorce, it does not guarantee victory in court. Under Section 13 of the Hindu Marriage Act, adultery is a ground for divorce. But proving adultery in court is challenging. It must be proven beyond reasonable doubt, and it's not enough to simply suspect it. So what are the other factors considered? The court looks at several factors like the welfare of children, financial stability, and contributions to the marriage. The division of property, alimony, and child custody are not solely determined by adultery. The case highlight of this is Joseph Shine versus Union of India. This landmark case decriminalized adultery in India. While adultery remains a ground for divorce, it no longer carries criminal penalties. This shows how the legal landscape has evolved to focus more on individual rights. This case challenged the constitutionality of Section 497 of the Indian Penal Code, which criminalized adultery only for men. The Supreme Court ruled that the law was discriminatory, violated the rights to equality, dignity, and personal liberty, and reinforced gender stereotypes. The judgment decriminalized adultery, emphasizing that consensual relationships should not be punished by the state, and marked a significant move towards gender equality in India. In the Joseph Shine judgment of 2018, the Supreme Court of India decriminalized adultery, meaning that it no longer considered a criminal offense for civilians. However, the court made an exception for members of the armed forces. On November 5, 2020, the Union of India filed a miscellaneous application asking the court to provide a clarity on how the judgment would be applied to members of the armed forces. This is with specific reference to Section 69 of the Army Act 1950, which punishes members of the armed forces for committing civil offences. The union sought to clarify whether this includes adultery practiced by armed forces members. So on January 31st, 2023, a 5-judge constitution bench led by Justice K.M. Joseph passed the final order on the matter. The bench clarified that while passing the judgment in 2018, the court was not concerned with the laws of the armed forces, and therefore it did not stand in their way. I'll explain the reasoning in simple terms. The military operates under a different legal system, governed by strict rules that maintain discipline and order. The court recognized that in armed forces, adultery could impact unit cohesion, morale, and overall discipline, which are critical for national security. Therefore, even though adultery is not a crime for civilians, it is still treated as a criminal offense under military law. This means army personnel can be held accountable for adultery, but for ordinary citizens, it is no longer a criminal matter. Myth 3. Divorce is a fast and easy process. Let's bust another myth. Divorce is neither fast nor easy, especially in India. The legal process can be long, complex, and emotionally draining. Under Section 13B of the Hindu Marriage Act, couples can file for divorce by mutual consent. While this is faster, it still requires a waiting period of 6 months between the first and second motions to ensure that both parties are absolutely certain. Contested divorce. This is where things get complicated. A contested divorce can take years. Grounds like cruelty, desertion, and mental disorder require proof, and the legal battle can drag on. The case highlight under this is Anil Kumar Jain versus Maya Jain. The Supreme Court held that mutual consent divorce is valid only if both parties maintain consent till the final decree. This case highlighted the importance of sincere consent in a quick divorce. In Anil Kumar Jain versus Maya Jain, the Supreme Court addressed the issue of divorce under Section 13B of the Hindu Marriage Act 1955, which allows for divorce by mutual consent. The court held that divorce can only be granted if both parties provide free consent at both stages, filing the petition and at the time of the final motion after 6 months. If one party withdraws consent before the final motion, the divorce cannot be granted, reinforcing the need for mutual consent throughout the process. Myth 4. Men always pay alimony and women always get child custody. Now this is a big one. Many people believe that men are always responsible for paying alimony and women always get child custody. In reality, the law aims for fairness. Alimony is based on the financial status of both the parties. Under Section 25 of the Hindu Marriage Act, either spouse can claim alimony. It's not restricted to women. The court considers factors like income, assets, and the duration of the marriage. The primary concern in custody cases is the welfare of the child and not the gender of the parent. Custody can be awarded to the father or the mother depending on who the court believes is in the best position to care for the child. The law doesn't automatically favor women. The case highlight under this is Gaurav Nagpal versus Sumedha Nagpal. This case stressed that in child custody cases, the welfare of the child is paramount and custody decisions are based on the child's best interest and not the gender's parent. In Gaurav Nagpal versus Sumedha Nagpal, the Supreme Court dealt with the issue of child custody under the Guardians and Wards Act 1890 and Hindu Minority and Guardianship Act 1956. The court ruled that the welfare of the child is most important in custody disputes, surpassing the legal rights of the parents. The decision reaffirmed that custody should prioritize child's best interest, including emotional, psychological, and physical well-being, and not just parental rights based on gender or status. Myth 5. Property is always divided equally. Now, many think that marital property is automatically split 50-50 after divorce, but Indian law doesn't work that way. India does not follow the community property system like some Western countries. Property division is determined by ownership. If property is jointly owned, it is divided equally. However, if it is solely owned by one spouse, the other spouse may not get an equal share. The court may grant maintenance, but that's different from claiming ownership over the property. Under Section 27 of the Hindu Marriage Act, the court can divide jointly owned property but doesn't redistribute personal assets unless under specific conditions. Let's cover some provisions. Section 125 of CRPC deals with maintenance to wives, children, and parents. Protection of Women from Domestic Violence Act 2005. Under this, Section 20 deals with monetary relief to women. Hindu Adoptions and Maintenance Act 1956 provides for the maintenance of wives and children. Alimony is decided based on several factors like the financial standing of both parties, the length of the marriage, and the ability of the spouse to support themselves. Myth 6. Divorce is the end of the story. Many believe that once the divorce is finalized, everything is over. But in reality, the legal battles may continue, especially regarding alimony, child custody, or even property disputes. Courts can modify orders related to child custody, visitation rights, and alimony even after divorce. For example, if there's a change in financial circumstances, either party can request a revision of alimony payments. Parties can appeal divorce judgments, leading to more time in court. Then lengthy court battles can be exhausting, both emotionally and financially. This is where alternative dispute resolution, ADR methods like mediation and conciliation comes in. ADR is becoming a popular alternative to courtroom litigation, especially in family matters. In many cases, couples are able to resolve disputes amicably with the help of mediators, reducing the time, cost, and stress involved in divorce proceedings. So, as we've seen today, the myths surrounding divorce and separation are often far from reality. Whether it's about alimony, custody, or property, the legal system in India is much more nuanced and complex. Divorce is more than just a legal process. It's an emotional, psychological, and financial journey. By understanding the myths and legal realities, couples can navigate these turbulent waters more effectively. Remember, the law is here to protect both the parties and ensure a fair resolution. I hope this episode helped clear up some of the confusion and gave you a better understanding of how divorce works in India. But before wrapping up, let's cover one more thing. Divorce doesn't just affect the couples involved, it impacts the children too. One of the most challenging aspects of divorce is the custody battle. Courts focus on the best interest of the child under laws like the Guardian and Wards Act 1890 and the Hindu Minority and Guardianship Act 1956. Custody can be awarded in several forms: sole, joint, or third-party guardianship. But the court also emphasizes the psychological impact of divorce on children, often recommending mediation and counseling services for families. Stay tuned for the next episode where we'll dive into child custody battles and explore the question: what's best for the child. Until then, stay informed, stay aware, and keep watching Family Law Diaries. Thank you for watching. If you have liked this episode, please subscribe to LiveLaw and hit the bell icon to stay updated on our weekly episodes. And don't forget to share your questions and experiences in the comment section below and share this with anyone you think might find this helpful.